Yes. Good evening, all. We will now start the meeting. I am Harsiddhi A, President of International Society of Computational Biology Student Council, Regional Student Group India, Tamil Nadu Node. It is my pleasure to welcome you all to our 8th webinar titled Intellectual Property in Life Sciences, Navigating Protection Strategies in Biological Data and Resources. We are delighted to welcome our distinguished speaker, Ms. Sakthiya Dakshi, who is a patent attorney and intellectual property lawyer. Before we begin the event, I would like to briefly introduce our organization. ISCB-SC RSG India is your local window to global opportunities in computational biology. ISCB is a global organization based in the USA that drives computational biology forward through research, training, outreach, and community building. The ISCB Student Council, started in 2006, nurtures the next generation of computational biologists with RSGs in over 26 countries. RSG India connects and promotes a strong nationwide network of computational biologists linking local talent into global opportunities. We proudly collaborate with premier institutions including Mahindra University, NIT Calicut, Manipal Academy of Higher Education, IIT BHU Varanasi, and SRIHER. Here is the RSG India Core Committee for the year 2026 to 2027, supported by faculty advisors and visionary leaders across India. RSG India has successfully organized impactful events in the past, fostering collaboration, learning, and innovation in computational biology. Here are pictures from some of the events organized from 2023 to 2026. You can reach us through our website or connect with us on social media platforms. The ISCB-SC RSG India Tamil Nadu Node is a student-driven community established in September 2025 to foster collaboration and growth in computational sciences across Tamil Nadu through Sri Ramachandra Institute of Higher Education and Research. This has been our core team for the year 2025 to 2026. We extend our sincere gratitude to the outgoing student team for their dedication in organizing events, workshops, and talks that built the foundation of this community. Before we continue, I am pleased to introduce the incoming student team for the ISCB-SC RSG India Tamil Nadu Node, effective for the year 2026 to 2027. We are glad to announce Meja Vivekanandan and Sarmishta Are, first-year MSc students at Department of Bioinformatics, Sri Ramachandra University, as the President and Secretary of the Tamil Nadu Node for the upcoming year. Midun Rashid, a final-year BSc student, will be continuing his role as Technical Head, Simin Suleiman as the Outreach Head, and Shakti Shri, first-year MSc student, as Treasurer. We are also glad to continue receiving guidance and advice from our faculty advisors, Dr. Dicky John Davis G, Dr. Abhinan PA, and Dr. Arundhati M. The composite committee involves members from a wide constituent of BSc and MSc degrees, Joyce Rakshana and L.M. Kogul from the program committee, Manjushri, Ridhnika, and Shakti M for the design committee, Ragamitra, Janani, and Kishwar Hussain for the finance committee. And the technical committee, composed of Jerlyn John, Sanyukta D.N., Michelle Ria Joseph, and Madhushri. Outreach committee consists of Purushothaman L., Karun, and Aishwarya Kalidasa. We hope the new team will carry this forward in good stead. And all of this is proudly hosted by the Department of Bioinformatics at SRIHER, whose alumni now lead cutting-edge research and industry roles across the world. Now, for the guest introduction, I would like to invite Dr. Abhinan sir to brief us about the guest.
Thank you, Arshidi. Am I audible?
Yes, sir, please go ahead.
It's a proud privilege for me to introduce the guest speaker of the day, Ms. R. Sakthiya Dakshi, who is the partner and co-founder of Taru Legal. And I'm really proud to say that she has been one of the closest friends in my life. I have known her from my childhood. We did our schooling together and literally grew up together. So now seeing her as a registered patent attorney, advocate, who's registered to the Bar Council of Delhi, who's representing so many prestigious clients across India, is a real proud moment for me. So now I go on to introduce the speaker of the day. Sakthiya Dakshi received her BTech in biotechnology from Sastra University in Tanjavur, and then went on to pursue her LLB from the Osmania University in Hyderabad. She also holds a PG diploma in intellectual property law from NLSIU, the prestigious institute in Bangalore, and she is registered with the advocate as advocate at the Bar Council of Delhi. Today, she provides legal expertise and assistance to diverse clientele, ranging from individual researchers, big universities, research institutes, incubation cells, startups, and IMSMEs also. And she also renders the services to even some of the bigger multinational corporations. She has wide expertise in filing procedures with the US Patent Office, the Indian Patent Office, and the WIPO also. She counsels clients on issues of patentability, infringement, validity, as well as licensing. And her practice areas include patents, trademarks, designs, copyrights, plant variety protection, biodiversity and repository compliance, geographical indications, and she has several licenses and accreditations to her credit. She is a recognized IP facilitator by the Government of India, and she is also a legal expert consultant uh, for the Technology Development Fund scheme of the uh, Defense Research Development Organization from 2020 onwards till today, and she is a registered patent agent. So, Satyad, actually, the stage is all yours. Our students are all very eager to listen to you. Um, Thank you.
Thank you for that wonderful introduction, Dr. Abhinand, or I fondly call you Abhi. Thank you for the introduction. Good evening, everyone. I hope all of you are doing well. First of all, I'd like to thank the Tamil Nadu node of the Regional Student Group India and the Department of Bioinformatics, Sri Ramachandra Institute of Higher Education and Research, for giving me this opportunity to basically keep all of you engaged during your weekend specifically. Thanks for showing interest in the webinar. In today's session, I'll be discussing the evolving landscape of intellectual property in this bioinformatics space, with a particular focus on patentability challenges, how the biological data, the inventions in the field of bioinformatics are being protected. What is the strategy that one has to follow in protecting this to get this competitive edge in this market, and giving you more practical vision and mission for protecting, strategizing the inventions in the field of bioinformatics. So I hope this session is going to be both informative and practical to you, and worth your weekend time. Thank you, and let's get into the webinar now. I hope the slides are visible. So yeah, IP in life science and bioinformatics field, and how we are going to navigate the strategies in protecting the inventions that you are going to come up, or any kind of product and process that is being developed in the field of bioinformatics. Before I get into onto that, I'd like to give a brief introduction about intellectual property rights. I hope most of you know or heard about intellectual property rights, but what it is actually,
Excuse me, sorry to disturb, but the slide is not visible.
is it? Oh, one second. I just shared it. Is it visible now, sir?
Very much. Thank you so much.
Thank you. Yeah, sorry for that disturbance. Yeah. Getting on to the intellectual property rights, I hope most of you have heard about intellectual property rights, but in this session, I'd like to
Just
give,
put it in presentation, please.
it is there. I have already shared it, sir.
No, click on the presentation down there, then you'll be able to see it.
It's not visible now again.
It is visible, but it's not in presentation. The thing.
Now?
Now it's not visible at all.
Oh, it is showing as shared.
If I may assist, under share window in the Google Meet, there is an option to click
No, no,
on
no,
one of
it's
our
shared
slides.
already. Sorry, it's already shared. It's showing me as sharing only. Actually, it's sharing a window.
Yeah, we are able to see your screen, but click on the presentation.
Yes. No, I don't think it's.
Just open the presentation. No, it's closed.
It's there. It's no. It's opened only in my. One second. One second.
We are able to see a screen though. Now it's gone.
I think some technical glitch, because for me, I have just opened only the PPT here. Can you please check now?
We are, yeah. Now it's perfect. Now it's perfect. You can just.
Sorry, I'm sorry. I think there is some technical glitch because it was open since the time I started. Yeah. Sorry for that inconvenience.
Now it's good.
Uh, yeah, so intellectual property rights, I hope most of you have heard about it, known about it. I would like to give you more insight on a practical perspective. What are these IPRs? What are the different forms of IPR?
Sorry to disturb you again. You
Yeah.
have another window that is open, that is
The Google Meet window.
Yeah.
So because
Can you minimize that one?
it's actually,
Yeah, just click. Yeah, that's all.
Yeah.
Now it's perfect. Thank you so much.
yeah, sorry, actually it was not working in other formats, so I just shared my whole window.
Okay.
Thank you. Thank you. So intellectual property, as the name suggests, it's a product that comes out of a human intellect. It can be either a script, a brand, an invention, anything that a human solely develops out of his intellectual idea. And these are called intangible assets. And these are exclusive of a person who is creating it, either a creator or a owner of an IP. So what is the point of having this intellectual property rights? It is a protection for the creator, that, where it gives a protection against any third party misuse or use without the creator's consent for any monetary purposes or for otherwise as well. Most of these intellectual properties are registered. Basically, these are recognized protection in India, and these can be registered with the respective intellectual property offices. And there are different forms of intellectual property which can be protected under specific acts and statutes, which are like patents, trademarks, copyrights, designs, geographical indications, and etc. There are a lot of this, and I'd like to brief about each of these important aspects of intellectual property so that you can understand how how we can utilize this for the bioinformatic inventions and products. The first important part is the patents. Patents are called intellectual property rights, and they are given, this protection is given only for specific set of IP, which we call as invention. Patents are the most effective intellectual property recognized and given by the government of India. It gives, so once we get a patent grant for your invention, it gives you a you in the sense like a person who has developed it, the researcher, the inventor, or or the applicant, whoever has filed it, they give a they'll be given a monopoly rights for 20 years from the date of filing this application, which means that no other party can use the product or invention or copy basically without the consent of the inventor. When I say the word invention, there is a specific definition to it in the Patent Act. An invention will be called an invention or recognized as an invention under the Patent Act only when it qualifies or complies with the three main criteria. Number one is the novelty of it. Whatever you are disclosing under a patent application as an invention should be new when compared to the existing state of the art or existing patent or non-patent literature, number one. Number two is involvement of an inventive step. The disclosure should at least contain one step of innovation in comparison to the state of the art or the existing technology. And third is it should be capable of industrial application. It shouldn't be just on paper, just like a discovery. It should be used for some kind of, in any industry, for the use of the mankind. So these are the three important criteria to get a patent for any disclosure. As I said earlier, once you get a patent, the owner has that exclusive right for 20 years. No other IP will give you the strict like a 20-year protection in any other IP forms you'll find it. Another aspect to remember for patents, specifically for the researchers here, is once you're coming up with your innovation, disclosure, or a research, please remember you have to file the patent first before you go for your paper publication. This is what I have underlined as one of the criteria as novelty earlier. Even though it's your own product, if you are publishing it for any kind of a scientific journal, and then after that, even with a delay of 1 or 2 days, you're filing a patent application, then your own scientific paper publication will be cited, and so which means that your patent application will lack novelty, which means that your own the disclosure is available in the public domain even before the date of filing of your innovation. So please, researchers, remember that at least file a provisional patent application with the minimum information, secure a prior date, and then you go for your paper publications or any kind of publication that will be available in the public domain. Yeah, this is what one is the paper publication, and the second part is any kind of publication. It's just not strictly paper publication. I just use that because that is more prevalent in the research industry. The second part is trademarks, which may not be really useful at this point of time to the researchers, but trademark is also another important aspect of IP, which is another form of IP, which protects the source or indication of the goods and services from one person to other. Like a trademark can be a word, a symbol, a device, a color combination, a signature, shape of the article, sound. All these are recognized a trademark if it is distinctive. Like a very good, what qualifies for a good trademark is basically it should be distinctive. In the sense, it should not be very descriptive of the goods or services that is being provided under that brand name. And it should not be identical or similar to an existing trademark registration or trademark applications. Like few simple examples you would have come across in your daily life is all these all are recognized as trademark, like a word mark, Amazon with a logo, just the device of the animal as Puma, trademark. Coca-Cola, here the shape of the bottle is recognized as a trademark here actually. So that's why so these are different forms of trademarks. So this is not really important for us at this point of time, because this is more when you get into the business, after you start a company, when you are actually going to start marketing, getting into the business of it, then you come up, you protect your brand names. Third form of IP, which is also important, is the copyrights. Copyrights is basically for this protection is for any literary, dramatic, musical, and artistic work. Why copyrights is important in the field of bioinformatics is because the algorithms, the database, it cannot be protected under Patent Act. These are recognized protection under copyrights. So copyrights for all these will be considered as a literary work because the source codes are basically, we protect source codes under the copyright protection. As the name suggests, if you see here, copyright protects only the expression of it and not the idea behind it. A very simple example I'd like to elucidate here to understand this phrase, like how copyright protects only the expression and not the idea, is with respect to computer program only. So the same idea can be expressed in two different computer language. One can be in C++ and other can be in Java. And the source code under each of this are protectable subject matter under copyrights. So it is only the expression that holds matter here under subject matter under copyrights, and not the idea, the end result of it, which is an opposite to Patents Act. Patents Act, we even Patent Acts, we actually disclose how an invention or a product or a process is basically defined. But again, that's more an idea, and here it's more an expression. Copyright protects both published and unpublished works. It's not like patents where novelty is favored. Here you can actually publish your work and then go for a copyright registration. For that matter, even registration is not mandatory here. Like how patents and trademark, even trademark, it's not mandatory. Like Patent Act mandates that you have to file your application before publication. Here, even you publish and just give a notice that you own the copyright and you hold all the evidence to show that you are the prima facie owner of the copyrightable subject matter, that holds more gravity here before the court of law than filing a registration. I mean, that's more than enough. But a registration certificate, of course, will serve a prima facie evidence, because you just have the certificate in your name. You don't need to prove the ownership by way of filing all kind of evidences. Here, the validity goes from life of an author plus 60 here. As I said, even without registration, you can just give a symbol like, C, which means that this is copy. So copyright is born on the same time when the work is created, because you are putting it in a tangible format. It's an expression. So whenever you're coming up with a source code and you have all kind of evidence like a date stamp document in your system, and all kind of evidence to show on so and so date you have created it, that's more than enough to show your ownership over the copyright. But of course, registration would be suggested in order to have an easy, hassle-free way of establishing the ownership. The fourth part I'd like to talk about is designs. Again, here, this is another important recognized form of IP in India, which is protected under a statute, but it's not more common in the field of bioinformatics, because designs, this registration protects as only the design or the external appearance or aesthetic of an article. It can be a features of a shape, a pattern, composition of colors, configuration of an article, anything that is applied to an article. Like there should be like an article in which you have applied that particular design. And second criteria is it should be an industrial process or means by which this design is being applied, and it should be an aesthetically appealing. Nothing related to the functionality aspect of an article is protected under design. This is only for the external appearance, and the statute exclusively disclaims any shape that is going to give a functional aspect to an article, then it's not protectable under this Designs Act. Maybe you can just know about this. Again, designs also work like patent statute, where novelty is the key. You need to file a design application before you go for publishing or marketing the product. The registration is mandatory here, and the validity again here is 10 years, and which can be extended for the next 5 years. There are other aspects of IP as well. Apart from patents, trademarks, copyright, and designs, there is something called geographical indication. There is a statute covering or protecting which guides how a geographical indication will be protected. Geographical indications are any agricultural or handmade, handcrafted article that comes from a particular region, like the basmati rice, Mysore sandal soap. It denotes with the origin of geography from which the product has been originated. So you have a special statute for protecting that. Apart from that, you have a Plant Variety Act, which protects the seeds, new forms of seeds, modified forms of seeds and plants, because these are not protected under patents. The subject matter of plants and seeds are not protectable under the Patents Act. So you have a separate statute for this called Plant Variety Act. And apart from that, these are the recognized forms of IP where you have a procedure for registration. Apart from this, you have other forms like trade secrets, confidentiality protection and stuff, but there is no statute to it. Trade secrets is more in India. It will be considered as a trade secret till the time you hold it confidential. And unlike US, you do not have a statute protecting trade secrets in India, unfortunately. And again, confidentiality, which is complementary with the trade secrets, your proprietary information, this proprietary information that you have come up with, which is an intellectual property, like you have developed it, but you are not, the subject matter is not fitting in any of these, either copyright or patents, then it will be just called as an IP, proprietary rights. So the only option here to have it as a trade secret, without delving much information about it to the public, and keeping it secret as much as possible, and having some watertight contracts with your vendors or partners who are using it. With that brief introduction about the IP, intellectual property rights, I'd like to get into the IP in the life science domain and bioinformatics. So the life science focused on the study of living organisms and their process, which includes everything from the genetic research, molecular biology to the development of drugs. Everything is called life science here. So we have a different set of IP aspects that can be protected. So here, since IP protection in life science domain is very essential because it is going to safeguard the innovation. It's a high risk innovation because the capital that is required in this domain is higher, and the reward is also higher. So in that case, of course, anyone would who is spending so much in researching and developing a product or process in the life science department would like to have it for themselves. It's very easy to copy, but how are you going to exclude these third parties who are eyeing on your product? So there comes the the IP plays a major role over there, which is going to give like a reward, which is going to reward you and also award you with a patent certificate or any kind of registration, which is going to give you a monopoly right for few years, and with which you can actually start a legal suit against a third party who is actually copying your products. And also with patents, you have that exclusivity, which means your products compensation and fee will be in a higher scale. So all these all these aspects needs to be seen at the time, or in case of IP protection. I'm sure everyone would have heard about this patented case like CRISPR-Cas9 gene editing tool, which is like a landmark and a life-changing patent that has been granted in India. And after that, I would say the biotechnology innovations in India started gathering much attention, because before that, India had a very, very stringent rule in giving or awarding patents to biotechnology inventions, because these involve living organisms and some kind of biological information. But yeah, after this, people started recognizing, people started getting awareness about IP, and biotechnology field specifically started gaining attention. So what can be protected and what cannot be protected? I'm specifically dealing right now with the Patent Act because that's the important IP protection that will be applicable for the research and development that's happening in the biotechnology and bioinformatics field today. So what can be protected? The compositions of pharmaceutical drugs, the genetic engineering processes, the medical devices, any innovative methods for manufacturing certain compositions of drugs, any agricultural innovations, and all other preclinical research data, if it is protected by patents. So these all are protectable. Now, here we need to understand what are protected under the Patent Act, because Indian Patent Act, as I said, they are very stringent in awarding patents, and they exclude specifically certain kind of innovations, though it is considered as invention. Let's say as per the act, though it it complies with the criteria of novelty, innovation, and industrial applicability, but still these will not be considered as inventions under the Patent Act. There are some exclusions, and out of that, those that are applicable for the bioinformatic and life science innovations, I'd like to mention here, which is number one is Section 3C of the Patent Act, specifically excludes any discovery of natural of scientific principles, like any mere discovery of a living thing or a natural substance is not patentable. Second one is the new form of drugs or composition without any enhanced efficacy, then it is not protected. So any new form of known substance, it's mere discovery again, it's not an invention. Any discoveries of new forms, new property of an existing substance, new use of a known substance, which does not or which do not improve the efficacy, you cannot protect under the Patent Act, because it often prevents evergreening. Basically, you would have heard this term evergreening in this patent domain, where specifically big pharmaceutical company, once they come up and get a grant for a composition, they just try to improve it further, modify it further, to extend their validity. Like, let's say, because since the validity of the patent is only 20 years, earlier, now the prosecution of a patent application, the time taken for the prosecution of a patent application has reduced quite a lot. But earlier, in my experience, this I'm talking about in early 2010s till 2020, I would say, the time taken for getting a grant from the date of filing will be more than 5, 6, or even 10. I've seen like it has gone to 10 years. Like, imagine, in the validity of 20 years, 10 years is actually gone and just getting in prosecuting an application to get a grant. So in that case, what these pharmaceutical companies used to do is, they try to modify the product further and file another additional patent in just to get more time, more monopoly rights. So which the patent office termed as an evergreening. And they said, if there is no improved efficacy, then you will not be getting a patent. The next form is basically under section 3.1. Section 3I specifically excludes the methods of treatment, any diagnostic treatments or diagnostic procedure. These all are considered non-patentable. Any diagnostic, therapeutic, and surgical methods for treating humans or animals. The next one is 3J. Here, 3J excludes plants and animals in whole or part, including seeds, varieties, plant species, and essentially biological processes. These all are excluded. And the last one is the traditional knowledge, which is more, like a parallel domain to biotech and life science department or inventions. Knowledge already which is available in the public domain, often passed down through generations, like this tribal information which we get, the antiseptic effect of the haldi, like of the turmeric, neem. These cannot be, like, whatever property you are discovering about an existing one, which is already there in the traditional knowledge of India. There is a journal, there is whole publication of traditional knowledge by Government of India. So these all are not patented. Now, coming to the bioinformatics, applying this, because bioinformatics again is an interdisciplinary field that merges biology, computer science, and IT to analyze and interpret the biological data on large scale. That's why I gave a very generic introduction about life science earlier and how IP works in life science. Here, bioinformatics generally covers 4 main areas. One is the biological database, bioinformatics software or algorithms, bioinformatics hardware, which is similar to the computer hardware, but it comprises of servers, desktop, like there is like a whole hardware environment which acts in tandem with the software instructions given to give you an input. This is how a patent office sees a bioinformatic product or a process that you are discovering or coming up or developing in the bioinformatics field. So and the fourth one is the biological sequences or molecules. These are the different aspects which we should actually focus on in getting protection. And let's see how IP helps in getting protection, like different IPs, what all IPs will be applicable in protecting each of this in detail now. So with that brief introduction about the IP, let's take patents first. Why someone would go for patents for a bioinformatic inventions or like a research that is involved in the bioinformatic field? As a high risk and high cost field, patents for these predictive tools like genomics or drug discovery tool, it gives, first of all, it encourages innovation. So encourages innovation in the sense patent certificate is something which is valid as the most important part in the IP. Because that's one exhaustive process to get. It takes some time and it's not easy, like in the sense like from the drafting, it's not just filing an application. Filing an application involves how you are drafting the invention, how you're drafting the disclosure to present it before the patent office, the claims, which forms the crucial part of your specification. The claims is going to define what is the scope of your invention, what is the scope that you're looking to get that exclusive monopoly right for 20 years. You need to be very, very careful, and drafting those claims and specification plays a key role in getting the patent. And so given the massive R&D cost, first of all, because the biotechnology field in India is still the most which actually asks for a huge capital, which asks for a massive R&D, which involves a massive R&D cost. And when someone, whether it's going to be an individual or a company who's going to put in so much money in the R&D to come up with a product, a human mind will always ask for the reward, and that's what patent is going to give you. Reward in the sense, first is the recognition that you have come up with the invention. You're going to be awarded a certificate which prima facie establishes the ownership of that particular product, number one. Number two is going to give you an exclusive right for certain years. Number three, you can stop any third party who's copying your invention or product, and you have the legal right to take them to the court, ask for damages, or or the loss, basically, if they have copied and manufactured those products in the market. Second, of course, as I said, it's the most strong protection you can have. And third is the competitive edge. With that patent, having a patent grant is going to give the valuation of a company which has a number of granted patents is much more than a patent pending or a company which do not have any granted patent. IP valuation plays a major role in terms of investments, in terms of marketing, because it gives you that customer attention. And as I said, with the proper claim drafting strategy, it establishes the technical effect that is being produced through the research or the disclosure you have come up with. And bioinformatics field specifically has seen major growth post-COVID within the IP protection. We have seen, and I mean, personally, I have filed a lot of inventions or patent application for inventions in the bioinformatics field. So again, coming to the specifically with respect to bioinformatics, what are the inventions that can be patentable and what are the inventions that are non-patentable? I'd like to give you a brief introduction here as well. And these are patentable inventions as listed here. These are generally these kind of inventions are getting more and more patent grant nowadays. This is like predicting gene expression using deep learning or trained algorithms, machine learnings, which identify disease-related genetic variants, which can predict diseases, of a particular person or in the family history. The artificial intelligence, which is playing a major role today, it also has a major role in the bioinformatics field. It helps in designing the synthetic biological pathways. Gone are those days where people used to do wet lab experiments. Now, if everything is simulation, there are synthetic biological pathways. The experiments are, we ourselves filed two, three patent applications in this particular field in last 2 years. Neural networks to analyze genomic data. So, and the system to predict protein structures. These are mostly patentable inventions. Now, focusing on those inventions which we might not get patents are the regular software. So here there is a trick. So Indian, as I informed earlier, Section 3K of the Indian Patent Act specifically excludes algorithms, source code per se, and they are, since they are not recognized inventions under the Patent Act. But how we usually project and draft these kind of algorithm related innovations in normally in computer science or IT related or bioinformatic related inventions are, we usually make it as a system and method for doing something where the source code will not be disclosed. It's more on how specific set of instruction is given to the hardware and environment to come up with the final output. So this is how usually the bioinformatic inventions are perceived under the Patents Act. So here I'd like to point out here Delhi High Court's observation in one of a landmark matter. Here the court observed that yes, there is Section 3K under the Patent Act, which has a history and various judicial decisions are there. But the bar on patenting in respect of computer program per se, and not all inventions based on computer programs. So in today's world, so the word per se is most important. So the Delhi High Court observed that in today's digital world, when most inventions are based on computer programs, it would be uh, retrograde to argue that all such inventions would not be patentable. So what they did is in the field, so what they finally observed is uh, they established and they basically made it a rule here that if a technical effect can be achieved through this kind of through the algorithm, then the subject matter is patentable under Section 3K. So this is the loophole for us lawyers as such, where we play around this rule and draft uh, inventions under the bioinformatic or anything related to computer program as a system and method of doing something, or system and method for getting this final output. So through this, there are a lot of patent applications that have got grants. Here, I'd like to give those examples. Specifically, identification of cancer protein biomarkers using proteomic technique, and method and system, as I said, method and system for digital markers platform. This was granted to TCS. The other one is a microfluidic device for a POC detection of oleophilic biomarkers in hydrophilic analytes. This was awarded to IIT Guwahati. Method of analyzing pluripotent stem cell biomarkers. This was awarded to a Singapore-based company, Ekigai PT Limited. Yeah, these are the few examples for Section 3K, which you might attract. It's not like the application will not, but this is how a legal argument is placed to mitigate that objection and to get the final grant. The other non-patentable inventions are like just the biological raw isolated biological sequence. This cannot be patented because it will come under Section 3J. Anything which is live, plant, animals, any biological processes, these are not recognized as patentable inventions. And the other one would be any invention that does not have a practical application. Like, let's say a discovery. There is a huge difference between a discovery and an invention. Invention should always have, as the third criteria for patentability, is the industrial applicability. So any product that can be applied to a particular industry to come up with the which can help the mankind, so that only those inventions are patentable. So any discoveries which is just on paper, they cannot be patented. And the other one is the method of treatment or method of diagnostics, therapeutic methods for treating or human animals, that is also not patentable. As I gave already, I gave these examples, specific examples. So some examples of informatic inventions that can be patentable, or genomic analysis using edge computing, AI-based drug discovery, patent recognition for therapies, all these are doable. So this is what is with respect to patents. Now moving on to the other aspects, specifically with respect to databases and algorithms, because these play a huge role in the field of bioinformatics. So patents are rolled out now because we have already seen what all are doable under the Patents Act. The copyright is what is the next IP that you can look for in case of protection of source code or algorithms per se. These are considered as just as literary work, and only those. Again, copyrights are not the strongest protection like patents. As mentioned earlier, copyright is going to protect only the expression of it, expression, how the source code is written, in which language and everything, and not the idea behind it. Apart from these two IP, for bioinformatics, there are no recognized IP as such, because trademarks, again, that is doable only for your brand names, not in the research and development field. Then all other aspects of bioinformatics, still though they are considered as intellectual property, they may not have a registered and recognized statute. But as I said earlier, since it's a proprietary, whatever you have come up with, and you think like it's a novel one, no one has done in the market, but you would like to proceed with commercialization, so this can only be treated as trade secrets. As the name suggests, this will be protected by the courts till the time you're holding it as confidential and secret. And so this cannot be revealed to anyone. So how are you going to protect trade secrets or proprietary information? You do not have registration to prove, but you have all the evidence that this particular company. So when I'm talking about a person, or you can like imagine either an inventor or a company. Here, trade secrets are more towards, I would say, as a company, let's say, in terms of protecting their proprietary information. First thing they should do is collating evidences to show that they are the owner. Second, they should have all kind of they should invest in all kinds of contracts in protecting this. For example, if I am the owner of a company and I'd like my team to work on it, that's not going to work unless and until I reveal this process or this proprietary information to them. So the first step is to have confidentiality, non-disclosure agreement with my employees, protecting this proprietary information. And next step, when I'm going to do the commercialization with that involves vendors or partners, same kind of watertight contract should be there, where proper clauses should be executed in protecting the confidentiality, and what will happen if the third party is going to breach this confidentiality agreement. These all is going to form a legal framework, because once a third party, so now what happens if a third party is going to breach the confidentiality? You have all the rights to take them to the court, because like Indian courts are very strict with the breach of confidentiality is taken as one of the strict matter here, because it's proprietary information. So for that, we need to show what kind of laws we'll be incurring in case, in such breach, during such breach, and what is the laws. So again, these are the legal thing. But for coming up with this legal enforcement, the basic thing is to have these documentation properly, because you do not have a registration as such on table like patents or copyrights. The next one is only to have the documentation properly. So in view of the brief given for the IP protection, what are the strategies now we'd like to see? For the researchers, specifically now I'm addressing the students and the researchers in the field of bioinformatics. There is no one one size fit all kind of strategy here. There's no one protection that's going to give you the monopoly right. So this is going to be like a hybrid IP protection or strategy you're going to follow. So number one, as I said, the strongest protection, patents. When you are researching, or when you're in half the way of researching during your PhD time or after the postdoctorate time as well, before you go for any kind of paper publication, try to figure out if the disclosure, the research you are doing or the development you're coming up with is patentable or not. Or I would say whether it is patentable or not, you can approach an attorney, and figure out whether a provisional can be filed. Just it's because provisional is going to be costing you less, but that's going to give you a date of priority and an application number. After that, you can decide whether you'd like to prosecute the application further. At least you file a provisional application and then go for your publications if it is mandated, and then the further development can happen. So once you file a provisional, you'll have 12 months of time to file your complete details of the disclosure. That is more important. So within this 12 months time, maybe your research should be completed. You'll have some kind of an idea how you're going to take it forward, whether you'd like to extend the provisional date further or file an application, or you do not want it. I mean, that's up to you. But I would suggest a better way is filing a provisional and then detailing or dealing with the other aspects later. Because once you get on to the paper publication mode or publication in any scientific journal, after that you cannot even think of filing it because the novelty is lost. So that would be the first strategy or first thing you'd need to keep in mind. Second thing, of course, approach any attorney to figure out whether this is a patentable invention. If it's not patentable, again, you can go for either copyright. Copyright would be much easier and cost-effective way. Second thing, when we are taking the patent application seriously, that when we have found the subject matter is doable, then you need to spend time and money in having a proper drafting of the patent application in order to get a grant. With respect to the companies, as I said earlier, apart from looking into these two aspects of IP, they should also have companies, specifically any startup or who is here aspiring to start your own company as a startup and get into your own business as an entrepreneur. You should always think the same strategy holds good for you, filing a patent and stuff. But apart from that, have your confidentiality agreements done, because once it is not, when your subject matter is falling in a gray area where you really couldn't get the patent also or copyright, then it's better to have it under trade secret, cover it under confidentiality agreements. The other one is to have an IP protection, to have it as a technology transfer agreements. So let's say here, what are technology transfer agreements is basically when you are transferring your IP by way of licensing or assignment to a third party. See, this is mostly done by all research institutes. The research institutes who have lot of number of granted patents. There is a vacancy still in India. The whatever the number of patents that have been granted, that's not been put to use, which is the basic soul of the Patent Act. Patent Act has been enacted only to encourage innovation so that it will be put to the use of the humankind. But there is still a gap in, there is a lot of gap between the IP that has been protected and granted and commercializing it. Without commercialization, there is nothing you're going to earn just by having a patent grant. It will be just a reward to you. Like as a researcher, you will just have a certificate that you've been in this research and you have got the grant. But after that, what? There is nothing. The whole point of having a monopoly right is to commercialize your product. So that's where this technology transfer agreements will play a major role. So now if you see, there are a lot of IITs, IISCs who have these granted patents. They usually have the technology transferred to a company who has all this capital and who can actually manufacture, who can actually commercialize it. Here you have to strategically see how you want to transfer the technology for for the monetary purpose. Either you can retain your ownership on that particular innovation and license it to the company. By way of licensing, you get like a certain fee for licensing, and when it is actually commercialized, you will also get royalty. Second thing is completely transferring the ownership. You do not own anything at a later point of time when you're going to assign the innovation or invention to the company. Then you are basically selling your invention for a wholesome money, and after that like the company will have the ownership and they'll take it forward. So these all are aspects we need to see in protection. It is just not only protection. At the end of the day, it's more on commercialization. So what are the strategies that you need to use for commercialization of the protected invention is also important with respect to like marketing the products and the inventions in India. And please remember, these IP protections, whether it's trademark, patents, and everything, these all are jurisdiction specific, which means there is specific set of laws that govern a particular jurisdiction. If you have a granted patent or a trademark or a registered trademark or a design in India, it is valid only within the geographical limitation of India. So you cannot stop a third party in US who's actually copying your innovation and marketing in the US, because you do not hold any rights over there in the US. So if you want to have that kind in other country, then it is advisable to protect your invention in those specific countries. See, practically it's not possible for any person, even if it's a like an MNC, multinational company, to have like go and file patent in each and every country in the world. And specifically, there's nothing called global patent. There is nothing called worldwide patent. There is an application named as PCT International, but there is no international patent. There is no body that is going to govern a worldwide patent. So the law differs in each country. The legal framework, basic framework, is going to be the same, but US has a more lenient approach in granting a patent, specifically with respect to computer softwares, than in India. As I said, India is very stringent in recognizing computer programs as invention and biological data as invention, but US is more lenient towards it. So these laws differ in each country, and when you want to have the protection and the monopoly right in particular country, you should go and file in each country. Yeah, with that, I'll close my speech. I hope the presentation was clear, and at least it gives a brief idea on how to protect your inventions or research. Please let me know if you have any questions.
Thank you, ma'am, for the excellent lecture. The floor is now open for questions from the audience. Please unmute yourselves and you can communicate directly with the speaker regarding your questions or write them in the chat. Ma'am, in the meantime, I believe you received a list of questions from the
Yeah, sure, I can address that. Yeah, I just thought like if someone is going to ask, I can take this up later. Yeah, I have certain questions. We received few questions from the students or the audience. One second, I'll just. Yeah, I have a question asking me, how do the IP rights differ in India versus that of US or Europe? So I think I just answered that. As I said, the IP laws, or any laws for that matter, laws are very jurisdiction specific. And with respect to IP, though India follows the European legal framework more than US, Europe and India both are very stringent in granting patent applications for biological innovations, but US is more lenient towards it. Like because Indian IP rights prioritize public interest more, and as I said, the accessibility of the invention to the public, they are favoring that rather than awarding patents for a broader business or software patents, like how a US does. They are very more, I mean, though the IP framework in India is more functional, but they are more restrictive in life sciences, with respect to Section 3D, which I also mentioned about evergreening in the pharmaceutical field. Uh, but US is more permissive here. And with respect to timelines, also timelines for getting a patent grant in India and US, India has become much better now. I'd also like to give you information about the amendments that happened in the Indian Patents Act, where education. So they have recognized categories of applicants, whether it can be just an individual inventor or a company who is a recognized startup, where you get a DIPP certificate, or whether a company who is recognized as a micro, small and medium enterprise, and or large MNCs. And the other category is also educational institutes, where because of that, there are a lot of educational institutes who are filing patent applications now. So they are treating the individuals, educational institutes, MSME, and startup companies at par for the purpose of payment of the official fee. And you also have, as an educational institute, you also have opportunity to fast track your patent application. As I said, in a standard prosecution, it will take anywhere between 4 or 5 years to get a patent. But under this expedited examination provision, my experience, we have got patent within 10 months, within 1.5 years. That's the least you can get. So that's in Indian government is doing quite well in amending these statutes in favoring startups, and because they want to encourage innovations, they are actually encouraging, and they're doing all kind of IP awareness, and like giving lot of benefits to these startups and individual researchers as such. So India is actually right now, they are the number of patent applications filed has also increased post 2020. India is working towards it, and I think it's going good over there. And as I said, IP rights differ. It is a legal framework, as majorly I covered how US is more lenient and how India is restrictive, because Indian perspective is to protect public interest. And the other question is, what do you think is the scope of genomics in the next 5 years from an IP rights perspective? See, I think we're going to see a lot of movement around gene editing techniques, because the CRISPR-Cas9, this dispute has already started gaining attention, and it's actually reshaping how a bioinformatic or biotechnology innovations is getting, will be perceived. Then it will shift from I would say genomics IP. See, it's going to shift from patenting discrete genetic sequences towards protecting mostly AI driven. It's going to be AI driven. So it's going to come up with protecting AI driven insights, more genomic data, functional genomic data. Analytical platforms is going to take over in the next 5 years for sure, specifically in the field of health, health industry. So yeah, in the next 5 years, I would say it's more towards AI trained or AI model platforms. I'm seeing the shift is going to, or focus is going to be here, specifically in the field of health sectors. The other question I think I have is, yeah, how can early stage researchers ensure protection of their computational work while still maintaining, open science practices? Uh, See, this is by just by using standardized open licenses where usage rights are defined, where restrictions are, prioritized properly. Like you have to employ a lot of restricted access repositories with respect to sensitive data, because here there is a lot of ethical issues also that may come up with respect to the bioinformatics research and development, because you're handling actually the genomics and biological data. uh, like who is going to own this data? It's more sensitive, it's more sensitive and personal data. So here we need to come up with a lot of restricted access. And the ethical problem or issue I was talking about is with respect to this data, and you are going to engineer this data, or and come up with the analytics. Who is going to own that? Because the personal information is the particular patient's. How we are going to use it, this is all going to come, this is a gray area still. In the next 5 years, maybe, as the earlier question talks about, this is all going to be the area topic for consideration. Maybe the government is going to come up with more like laws and regulations, how this is these all going to be handled. So yeah, early stage researchers, you have to use standardized open licenses in order to define the usage rights, restricting the access for sensitive data, and utilizing various version control systems in order to document things. How does Next question is, how does AI play a role in securing biological data? Of course, it's going to be it's going to play a crucial role. Just not in bioinformatics, AI is already taking up everywhere, and next should be the because bioinformatics is it the platform is going to be built now in the AI. So it is going to take up in securing the biological data. It's going to come up with automated analysis to identify threats, to identify, protecting, I'm sorry, to identify threats and protecting privacy. This is all needs to be taken up during the collaborative research, and it ensures data integrity in fields like genomics and drug discovery. So, but we also need to have in mind, but with this, AI also creates new risk here. Again, like it can be used to reconstruct data that maybe that you don't even mean to come up with that. So it's a double-ended sword here. AI is going to be a boon and a kind of a disadvantage to us. Like it depends on an individual, the researcher, how he's going to implement AI and how he's going to monetize by implementing AI in this field in a very, very strategical and clever way. You have to, the researchers have to think about the ethical issues that may come up with, and also how AI is going to, act on its own. So these are needs to be considered. Other question, one more question is, what diploma or certification courses are available for industry professionals to develop advanced knowledge in IP? Which of the courses can also help build a strong career path in the IP field? See, as such as an IP, yeah, just to give you an introduction background, even I'm an engineering, I did my engineering in biotechnology. And since I had my patent paper, last final paper was in the intellectual property, I was interested, and after that I took up. Hello.
என்னதுக்கு அதை மியூட் பண்ணீங்க?
இதையா?
Sorry. So yeah, after that there are a lot of law colleges that offers diploma courses, which I did is from National Law School, Bangalore. There is also all national law schools in Hyderabad, Bangalore, and other parts of India, they offer this PG diploma course. It's a 1-year course which gives you an insight, a clear insight, what's happening and stuff. Though it may not be practical, but you can have a proper knowledge about IP through these courses. You have a diploma course in WIPO Academy Advanced Courses also, World Intellectual Property Office. Please check their website. They have some online courses and certifications. I would say though these courses only will give you like a brief knowledge about the IP. Your practical for with respect to patents on a practical scale, I would say you should start reading the Act, Patent Act, read about it, and try to attend the patent agent exams so that you can become a patent attorney. Because like lawyers cannot practice in patents. Patent Act mandates that an attorney who is actually prosecuting a patent application should be a graduate in science background, science and engineering background. So you guys will be very much eligible for the for attempting or giving the patent agent exam. That's going to give you a Government of India recognized patent registration, patent agent registration certificate, and you can file your own applications also, and you also have good career in the patent field as such. Please check ipindia.gov.in. That's the IP office official website. You have announcements every year when the patent agent exam is going to be coming up. Next question is how.
May I please request, could you please turn on your camera?
Oh yeah, sure. Any other questions, or I can take up this? I have a few more questions left.
I believe we have one question in the chat room.
Okay. How do we balance protecting innovation with making sure critical data is shared during global health emergencies? So here, as I said, see, again, this is a gray area. Protecting your innovations, and when you're sharing certain kind of sensitive and personal data, contracts will play a major role. Even if there is a health emergencies, like however it is, there is there is something called consent forms you get from the patients whenever like a hospital is analyzing their data or taking their data. The mandatory thing is like they have to get the consent form. Specifically hospitals as such, I'm talking about the softwares they are using. So online consent form is important, where you get consent from the patients that you are going to use and analyze their data to come up with like analysis and stuff. And when you're transferring this data with third parties, please have some kind of contracts where personal and sensitive data are being transferred. And this is very normal. Any software, if you go and see any kind of software platforms that is being employed by hospitals, anything in the health sector, basically, these are the clauses we come up with. The privacy policy is an important one, and which mandates that this is like under the IT Act and IT rule. IT Act and rules mandates that how a person who is actually taking personal and sensitive information, how they are going to deal with this information, what they are going to do, who is the owner of it. Everything needs to be done or defined in your contracts that you are going to put up in the license agreement along with your software. When you are transferring it to someone, that same needs to be maintained, because the same kind of rights is transferred from X to Y to Z. So if the contract between X to Y is good or watertight, and Y to Z is actually not mirroring the same thing, then Y will be under the radar. So these all should be protected under proper contracts. And again, I would say enforcement or how the misuse of these things are still under gray area, but like of course sensitive data misuse is like a grave criminal offense, so that needs to be taken care properly. Shall I take up the next question?
Yes, ma'am.
Sure. The next question is how to protect novel clinical decision support system from being replicated. This I think we have covered again. Again, the system, we need to see whether it's patentable protected, then we need to go for patents to cover the specific diagnostic applications, the system as such, and for the source code, you have to go for copyrights. The next question is how does the knowledge of IP rights integrate with bioinformatics? IP rights is more a legal framework. It should be the awareness should be there for just not with bioinformatics, for any field of science as such, and specifically for life sciences. Why? Because of the amount of money the person is going to put in for the bio life science research is more, and monetizing from that in a proper way will be only through or only by way of protecting it first under the IP protection, because it gives you a monopoly right. So it is a mix and match. I mean, it is always connected. IP rights is always connected with the innovations or in the field of life sciences. We need to make sure how these IP rights can be monetized. That's the important part. How we are going to, so protection is apart from having a moral right and a reward that so and so has come up with this, the IP protection is also going to help you in monetizing from the innovation when you are commercializing it. The other question is for researchers in India who are interested in transitioning into intellectual property or technology transfer roles, what specific skills or experiences should we start building earlier in our career? See, early in your career, as I said earlier, these PG diploma is going to help you, because I'm sure you will be all PhDs, PhD holders, or who will be working PhD now, and you already have graduation and post-graduation. So you can go for PG diploma. It's just a 1 year, either it can be an online course or like offline course. You don't need to go to the college. So this course is going to give you a lot of insight in IP, practical, some practical theories or cases also you can study. Once you have that kind of a knowledge, then you can figure out how you are going to, where you are going to get placed. So after that, either do your patent agent exam, give your patent agent exam so that you can work as a full-time patent attorney in a pharmaceutical company or any company in the biological domain, or if there, even there you can come up in with the IP cell. As a lot of bioinformatic and biotech MNCs have their own IP cell. They do not outsource their work to law firms like us, like Biocon. They have their own IP cell. They used to earlier, but now they have their own IP cell, IP team. There's a team of attorneys, patent attorneys specifically, strategic advisors who know law and IP, who cannot practice as a patent attorney. They are more into advisory. So with this practical experience only, you will gain more knowledge, and you can go move or shift your focus later. But yeah, start with the diploma courses. Even WIPO online course will help you, and yeah, that should work. For students from biotechnology backgrounds, what skills are essential to enter the field of IP in life science? Do you think current IP laws are sufficient for emerging fields like synthetic biology and personalized medicines? I think the first question I've just answered. Do you think current IP laws are sufficient? For now, it is yes. See, the law is always an emerging field, because law will always get amended based on the development that's happening commercially, scientifically, and in research wise. So whenever there is a need, the law will always get amended and get up to date to protect the gray areas. If something is found in a gray area where it is not regulated, of course, the legal department or the legal department comes and amends the statute and rules. But I think as of now it's going good. As I said, India is still like little stringent in awarding biological innovations. I think the perception will change in few years down the line because AI is taking up. Yeah, I think I've covered mostly all the questions that was given to me. Any other questions, guys?
There are 3 more questions in the chat room.
That's fine. What if we find any methodology or procedure present on older books and in recent times we want to create a brand around it? Can we do it? And also, is it a legal? This question, I'm still not clear with this question, but I understand you're saying, what if you're coming up with some kind of improvement based on methodology or the procedure that is already there in the older books? Is it? See here you need to figure out what kind of IP protection you're looking for. Let's say if it's a copyright protection. I'm talking with the copyright protection perspective. Then, if you're using someone's copyright, let's say, like a procedure that is copyrighted or subject matter that is copyrighted, and you're coming up or building something from that, the copyright law mandates that you need to get a no objection certificate from the author, where you acknowledge that yes, my work is an adaptation or improvement or modification to it, and which is available in this
Excuse
thing,
me.
and so. Hello.
Excuse me. So I think what the person means is there are some age-old protocols in molecular biology, like protein extraction by Lowry method or God pot for protein glucose estimation. These are like 78-year-old methods that have existed. So we don't even know who holds the actual copyright for those. And these are part of all textbooks. So I guess he's asking if we can improve upon the existing method and come up with our own modification of it, will that be patentable?
Absolutely. So any modification and improvement is patentable. Again, subject to the compliance to the criteria of whether how innovative it is. See, let's say like this is already there. For sure. So the process of patent or prosecution of patent goes like this. Once you file your application with the complete disclosure of your invention, then the patent office is going to take it up for a detailed examination. This examination is going to take like for easily 6 to 8 months in a standard way for the patent office, because the examiner will conduct a very defined and refined search to figure out if any patent applications or granted patents or any non-patent literature exists which has similar feature. If they do find anything, then you will be receiving a objection letter citing this particular feature is similar to so and so. So in your case, if even if the patent office is going to give you an objection letter saying this is an age-old thing, now the strategy is how we are going to mitigate it. We need to prove how innovative or we need to prove the presence of at least one step of advancement, improvement in your invention compared to that existing methodology. With that, we'll be able to mitigate it. If we prove it, I mean, that's it. You will be getting a granted patent. So the key is what kind of technical effect, in what way your invention is going to do, whether it is economically cheaper than whatever available, or whether it's going to give an higher efficacy, or whether your system is going to come up with more efficiency. Then if you're proving all these things, yes, then your improved or modified system is a subject matter of patentable. I hope I answered the question. In the next question is, in bioinformatics, how can we show technical effect to make an algorithm-based invention patentable? See, again, as I said, technical effect is what is the end product, what is the end result, and again, as I mean, it goes to my previous answer. The end result, how efficient it is in comparison to the state of the art, or how economical is it. Either it should be more efficient or economically cheaper. So if we are going to prove either of this, this is how we will show a technical effect in any invention. And with respect to algorithm based inventions, yeah, this is how we show the technical effect. For a bioinformatics startup wanting to build a SaaS platform that may inadvertently use a patented algorithm or method, what is the step-by-step procedure in India to identify, approach, and negotiate a license with the patent holder? What happens if they refuse? Suppose I want to launch a cloud-based variant calling service. Oh, you're asking me more a legal advice here. So this Harshidi, okay, Harshidi, do you want to take my legal advice? Then I think I need to speak with you personally. But yeah, jokes apart, see here, approaching a third party, getting a license negotiated is there is no one size fit all approach. It completely depends what is the domain, how we're going to approach them, whether they are even interested in it, what kind of uh, model you have, what kind of business strategy you have, how much you're willing to pay them as a royalty or license fee. There are a lot of factors here. Negotiating a license agreement is not easy, and as again, there is no step by step process, because this is not a defined statute here. This is more on one to one approach. And
Yes,
first of
ma'am.
all,
Sorry to
yeah,
interrupt. If you could please read the last line of my question, I think I have mentioned
do I
if it
need
is
a license
required.
upfront, or I can argue fair use or research exemptions? Okay, here research fair use concept comes up when you are going to prove that you are using it only for the purpose of research, and there is no monetary consideration or monetary aspirations involved over here, and it's only for your pure research and teaching purpose. Then it comes under fair use. Then it's doable. But let's say if you're actually building a SaaS platform, let's say, I'm just giving you an example on that particular algorithm, and going to launch it just for a trial basis, there are a lot of chances that company is going to come against you. Again, over there, we need to prove how we are actually using it only for the testing purpose. But when you're actually coming up with a SaaS platform, I don't see any fair use over here. You're not doing any kind of research. If it is inside your own lab, or inside your own I mean, in your own system, just for a beta version, it's okay. Even beta versions will be available in public domain. So I mean, you cannot the chances of the third party or the particular license holder, the proprietor, coming against you cannot be ruled out if you're going to launch the SaaS platform without their consent. But yes, for a research purpose, fair use concept can be for fair use mechanism can be taken for sure.
Yes, ma'am. Thank you for clarifying.
No worries. Any other questions?
Hello, ma'am.
Yeah. Hi.
Hi, ma'am. So I have an idea where we use the patient's detail, like family history, to estimate the genetic risk. So, so whenever we pitch this idea, we come up with a question like, what is the regulatory compliance you use? And also, this is going to be a repository like website. So we are also going to use like other research articles and videos. So what are the other acts we have to follow? What kind of legal problems we might face?
Again, see the same thing as I also mentioned about the ethical issue earlier. This is again a gray area here. How we are, as I said, AI is going to use the family trends, family history. See, when it's going to use that, it's an unregulated area in India as of now. I'm sure the government is going to come up with because it's similar to your privacy policy or handling of sensitive information. Maybe you would have, or wherever you would have got this information from, directly from the patients or from some other website, they should also comply. They should have also had complied with this privacy policy on how to handle the sensitive information carefully. Because these are health related informations, and it, like, it should be in a very personal name should not be involved. You cannot basically trace back to the patient's name, with the help of this information. So this is a little unregulated area. Again, I understand where the questions are coming from when you're using building a platform on this. But the only approach is on carefully handling the sensitive, data and the basically health related information. And on how, when you're using the other, the second question on when you're using the other copyrighted works, right?
Yes.
Here
Like,
acknowledgement is the only the maximum thing I understand is, like, if you know the owner of the copyright or who have come up with, we usually acknowledge it, because it's their moral rights. There are a lot of work, the copyrighted work, anonymous copyrighted work available over the public domain. So here you just need to put the source information, where you have gotten the information from. That would be less risk associated, because we neither know the person who have come up with, and we don't know how to actually get the license from. So that will be the better approach if some kind of legal action comes against you, because you can always say, but make sure that you actually make sure that it's actually anonymous. If you know someone's work, then you can approach them for a license, right? If not, the best or less risk associated option would be to acknowledge the source from where you have gotten the information.
okay, thank you so much.
Thank you.
I think with that, we have come to the end of the Q&A session. We would like to thank our speaker, Ms. Sakthiya Dakshi. Thank you, ma'am, for accepting our invitation and taking the time to share your knowledge with us. I'm sure it will inspire a lot of research-based entrepreneurship in life sciences for all of our young researchers. Thank you so much, ma'am.
Thank you for the opportunity.
I would like to add a few words. So, my heartfelt thanks to Sakthiya Dakshi. I know how busy you are. To having taken 2 hours of your time and spending it for our students. Thank you so much. We are very, very grateful for that. And, and especially doing it at such a short notice without any monetary gains. It was a great gesture from your part. Thank you so much. Very, very grateful for that.
Thank you. My pleasure, Abhinand. Thank you. Thanks for everyone.
And I hope you also had a good time interacting with the students.
Absolutely.
And to the ISCB office bearers who are completing their tenure today and passing on the baton to the next batch, my heartfelt thanks to all of you. You have done some amazing work in the last 7 months. You started this initiative, Hashidi, Syed, and all the other office bearers. You have done a remarkable job in starting this journey. I'm very sure that we are only going to get stronger and stronger through the years, and your juniors are going to carry on the legacy that you have started. So, congratulations to all the office bearers who are graduating in a few weeks from now, and congratulations to you. Thank you.
Thank you, sir, for the kind words. And once again, thank you, ma'am. And thank you to all the participants for joining us in our meet today. If you could please direct your attention to the chat box, we have posted the link to the feedback form for you to receive your e-certificates and post your review on the contents that you have learned today from our speaker.